This is ABC 7 News This Morning.
Well, it is a question that could be crucial to the murder case against Drew Peterson. Can hearsay evidence be admitted at his trial? A judge will decide as a landmark hearing gets underway today. Jason Knowles was telling us a little bit about it. We want to get some real legal expertise. Attorney Thomas Glasgow is here.
Good morning.
Good to see you again on this thing. This is a complicated, you call it a landmark possibility.
That's
what exactly is the definition of hearsay when we're talking legally?
Hearsay is an out-of-court statement that's used to prove the truth of the matter asserted. In other words, if you see A shoot B, and then you go to the police and tell them you saw A shoot B, and then don't show up for court, then they can't put in the statement that you made to them through the police officer or through a writing. So in this case, what they're attempting to use is Stacey Peterson's own statement to her priest, her sister's statement that allegedly was made to her, and the sister of Kathleen Savio's statement. They're trying to introduce these things for the proof of the matter asserted. In other words, that Drew killed these people.
What's the exception to this rule as it's generally applied?
The exception here is that if the witness or the defendant made the witness unavailable to testify, then they can utilize the out-of-court statements regarding any matter if that issue was part of the trial. And what the judge is going to have to do is he's going to have to take, by preponderance of the evidence, or 51%, determine whether or not, first, Drew Peterson made the person unavailable to testify, and second, whether or not that evidence is admissible in court for reasonable and reliable definition for hearsay.
Am I correct in thinking that this whole new law here in Illinois was based on this Peterson case?
You're correct. This was known as the Drew Peterson law. And essentially what they did is the Will County State's Attorney lobbied the legislature, and they voted, it was 119, I think, to 0 for this law. Now, the problem with this is, as you and I were discussing, the constitutionality of this issue. You have a right to confront your witnesses. And as we were also discussing, the state of Illinois doesn't exactly have the best track record for putting people behind bars for crimes that they committed, especially murders. With the wave of people that have been exonerated, you're now going to base this case largely on hearsay statements that are made outside the presence of a witness that could be cross-examined by the defense counsel, and you could ask some questions about how, why, where, what was the statement made, and why was it made, and under what circumstances was it made. And you run the danger of having a murder case where someone who is upset or angry and truly believes that that person committed the crime making that statement.
So what if today, if the judge does not allow this evidence, what happens in the prosecution's case?
That's a very good question. This case is largely based upon some of those statements. You've got the exhumation of Kathleen Savio's body for the purposes of determining whether or not she was actually murdered. Remember that she was first ruled to be an accident, now it's ruled to be a murder. This would bolster that case that there's a murder as opposed to it being an accident, and helps get you past that threshold of beyond reasonable doubt. The danger is you've now got a judge who's determined that that statement is reliable, and we don't live in a vacuum. The jury pool may believe that since the judge already found that to be the case, then it actually is the case.
Well, this is crucial. We thank you for sorting some of it out for us. Appreciate it, Thomas. Always good to see you.
It's good to see you, Joe.
We'll be right back.